Today on Legalese, we are going to be discussing the Supreme Court's Takings Clause case, Devillier v. Texas, and how we seem to be on track for a major victory for property rights. Hey, greetings everybody, and welcome back once again to Legalese. As always, I am your host, Bob, and I want to thank you all so much for joining me here today. Now, if you happen to be new to my channel, let me especially welcome you. This is a podcast where we're going to be discussing all things constitutional law, as well as current events in other areas of law, politics, and culture. Now, just to remind you guys, if you want to learn more about the show, you can go check out our homepage over at legalesepodcast.com. And if you want to stay up to date with all of my latest content as it is put out, you can go to legaleseshow.com. There you can subscribe to my newsletter and you will get notifications and updates anytime I post, whether it's a video on YouTube or an article on Substack or anything like that. So, anyways, it's been a while since I've done a video. We have a lot to talk about today, so I suppose we should probably just jump right on in here. So as I mentioned right off the top, we are going to be discussing Devillier v. Texas. Now, this is a case that we have already been following here on the channel as part of my annual Supreme Court Roundup ever since the Supreme Court chose to grant cert on this case back in September. And the reason we're revisiting it today is because on January 16th, the Supreme Court heard oral arguments in Devillier. Now, this is just a quick sort of refresher for people, an important Takings Clause property rights case. Now, the Takings Clause constitutes the part of the Fifth Amendment which reads that no property shall be taken for public use without just compensation. And based off of what was said in the arguments made before the court, I think it is very likely that we are going to see a win for the property owner and that this outcome will be a significant victory for property rights generally. Now, Devillier v. Texas constitutes a very common type of takings case that is known as an inverse condemnation case. And this refers to cases where, rather than the government seizing property under eminent domain and providing just compensation as a matter of course, the property is taken de facto. Now, in this particular case, Texas did not come to Devillier to buy the property for some public use. Rather, in the case, the state of Texas flooded Mr. Devillier's ranch as a result of a highway project, and this flooding made his land worthless. Now, when he would go on to file a takings claim in state court, Texas would remove the case to federal court under 28 U.S.C. Section 1441, which allows defendants to remove to federal court any civil action brought in a state court of which district courts of the United States have original jurisdiction. And Texas would then go on to persuade the Fifth Circuit Court of Appeals to dismiss the case on the ground that it could not be brought in a federal court because Congress has not enacted a statute allowing a property owner to do so. Now, if this is allowed to stand, this maneuver will create a catch-22 under which states can entirely evade Takings Clause liability by removing a case to federal court and then simply having that case dismissed. Now, an alternate problem is what are known as rogue states, and these are states that simply choose not to allow to bring such takings claims in their state courts in the first place. Now, as far as this particular catch-22 goes, the Supreme Court actually already signaled that these sorts of catch-22s barring takings claims from federal court are impermissible, and they found this in the 2019 ruling in Nick v. Township of Scott. And based on the oral arguments in Devillier, The justices are absolutely not going to allow Texas to bring back this sort of catch-22, which actually in Devillier is in even more egregious form than the one they abolished in Nick. Now, as far as my own first impressions of the case following oral arguments, I found it especially encouraging to see a general agreement among the justices that what Texas was trying to do here is entirely unacceptable. And I found this encouraging because takings clause cases tend to split the justices along ideological lines, with conservative justices siding with a strong defense of property rights and liberal justices siding with the government's claims of sovereign immunity. However, in this case, Justices Jackson, Kagan, and Sotomayor all appeared every bit as skeptical about the state of Texas's dubious claims as did the conservative justices. And it is for this reason that I actually would not be surprised to see the court resolve this case with a unanimous 9-0 decision in favor of the petitioner. However, where there is some uncertainty here is about exactly how the court will act to resolve this case and the reasoning the court will use to make its decision. Now, this is especially important when you consider how the Fifth Circuit handled this case. In their incredibly questionable and cursory opinion, they ruled in favor of Texas on this claim. However, their opinion is literally only a few sentences long and does not even mention most of the major federal precedents that would bear on this case. Now, before reading the Fifth Circuit's decision in this case, I would have thought that this issue was just done and settled and just completely dealt with because of the 2019 decision in Nick. And in the Nick case, the Supreme Court would reverse a 1985 Williamson County case where the court had held that before you can bring a takings claim in federal court, you first have to go through all possible state court remedies. And then, when you're done, it may very well be that you can't bring the case in federal court after that because of various procedural doctrines. And in this case, the catch-22 is arguably even worse because while under the Williamson County regime that Nick reversed, while you could not go to federal court initially to file your takings claims against a state or local government, you could at least go to state court. But in this case, if you go to state court, Texas pulls this trick of removing the case to federal court and then getting it dismissed. And there would obviously be any number of dangerous consequences to letting this decision stand. And this is because the fact that if Texas was allowed to do this, this would guarantee every other state the same opportunity to do what Texas is attempting, which is to not allow the case to be brought in either a state or federal court, which essentially allows them to take property without any recourse for compensation. And it would therefore render this constitutionally protected property right that is inherent in the takings clause non-existent. And I think, therefore, on this central issue here, this should be a relatively easy case insofar as the whole question is whether you can bring a case in federal court under the federal Constitution. Now, during the oral arguments, I think all of the justices, both liberal and conservative, made many of these same kinds of points that I just made myself. Now, when the obvious catch-22 nature of this issue came up, even Justice Sotomayor described what Texas was doing as a bait and switch. Now, Sotomayor has proven herself time and again to be the least sympathetic member of the court to citizens who are seeking to protect individual property rights. This means if Sotomayor's vote is in doubt, then Texas must recognize that they are not in a particularly good position, legally speaking. Now, Justice Kagan would emphasize that there is an ongoing violation of the Constitution in a situation where the state has taken property but not paid for it. And that when a federal constitutional right is being violated, that surely the court has the ability, if not the duty,
Duty.
to do something about it. Now, in this case, the court also heard arguments from the Solicitor General's office as well. Now, they had the audacity to come before the court and argue that maybe you don't actually have a right to bring a claim for damages in a federal court, despite the fact that the Fifth Amendment provides an explicit guarantee of precisely that. So, what the Solicitor General's office instead said, which is a profoundly baffling argument, is that maybe you might be entitled to seek an injunctive remedy. Now, this is a kind of relief other than monetary damages, and it usually involves a court order demanding another party to either do something they're not doing or stop doing something they are doing. And as Justice Kagan would point out when during the Solicitor General's discussion, was that in this case, the whole nature of the constitutional right is in fact a right to be paid monetary compensation, and that the Supreme Court has repeatedly said that in a variety of similar cases, that there simply is no injunction that could deal with a takings clause claim. And the thing is that this has been precisely the government's own argument in other past cases. Now, the reason for this is simple. Texas cannot unflood Mr. Devillier's property. So, as far as I know, because neither Texas nor anybody else has the kind of time travel technology that would be required to go back in time and prevent the flooding in the first place, this makes injunctive relief without compensation just a completely meaningless remedy. And again, as various justices have pointed out, there is no way to deal with a temporary taking on this basis either. This is if the government has temporarily intruded on your land or temporarily hampered or damaged your land, then an injunction cannot fix that. The only way to fix that is monetary damages. Now, of course, in this instance, the right to be paid compensation is written right into the Constitution. Now, in addition, several of the justices raised an issue I mentioned earlier in this video, that is rogue states. Now, this is where a state simply does not provide a remedy for a takings clause violation in their state courts. And this is not purely hypothetical. Just one example is Louisiana, which, like Texas, is also in the Fifth Circuit. This is a state with no state remedy for a takings violation. And as the counsel for Devillier pointed out, there are lots of states where state courts have said that the only reason that there is a takings remedy in a state court is because the federal Constitution directly requires it. If the court were to uphold what the Fifth Circuit did here, then that requirement would simply fall away. And more generally, every state government would, at least in some cases, love to be able to get away with taking property and not paying for it. Now, this is something they do all the time, and there are a number of fairly obvious political and economic reasons for them to do this. Now, just look at how states handle other forms of government theft of individual property, such as civil asset forfeiture or home equity theft. Now, of course, home equity theft is something that the Supreme Court ended in their case last term of Tyler v. Hennepin County, which we covered, but that still doesn't change the fact that most states were trying to do that. So while I think it's clear that the court will be deciding this case in favor of Mr. Devillier. What is uncertain is exactly how the Supreme Court majority will provide the remedy that he is seeking, because they have several options. Now, at the very least, they will reverse the badly flawed lower court ruling which facially denies the Supreme Court's landmark case of Nick, as that case clearly did forbid the precise catch-22 that Texas is relying on here to win this case, just as they did in the Fifth Circuit. Now, beyond that, I think the simplest and best solution would just be to say that you can bring a case in federal court directly to enforce the takings clause, and this would entail making just a modest expansion to the court's existing takings clause jurisprudence. While they could instead say that you can only bring a federal claim if there is no state court remedy, they could also potentially just rule that the removal to federal court under Section 1441 was purely inappropriate. And those are the couple of major options that are before the court. And I hope and I think there is a good chance that the court will simply say that these kinds of cases can be brought in federal courts, in part because of the special nature of the right here. But again, they do have some other potential options that we can't just write off completely. And another uncertainty will be the final vote. Now, as I've said, based on the oral arguments, I will be very surprised if the final vote is not unanimous. But because takings clause cases do tend to split along ideological lines, it's not impossible that one or two of the liberal justices might choose to dissent all the same. It's also possible that we get a unanimous decision with a 6 or 7 vote controlling opinion and a 2 or 3 vote concurrence in which the liberals join the primary holding but give their own separate reasons about why it was the right decision. Now, they could also potentially hold, and I think they likely will, that the distinction between damages and injunctions that was argued by the counsel for the Solicitor General's office just doesn't make any fucking sense. I mean, after all, if this is the very best argument that the Solicitor General's office can come up with, in an argument before the highest court in the land, they might as well have sent in Lionel Hutz to represent them.
Don't worry, Homer. I have a foolproof strategy to get you out of here. Surprise witnesses, each more surprising than the last. I tell you, the judge won't know what hit him.
Pipe down in there, Hutz.
Now, all they accomplished here was making Texas look good by comparison.
Ladies and gentlemen, I'm going to prove to you not only that Freddie Quimby is guilty, but that he is also innocent of not being guilty. I refer you to my expert witness, Dr. Hibbert.
Well, only 1 in 2 million people has what we call the evil gene. Hitler had it, Walt Disney had it, and Freddie Quimby has it.
Thank you, Dr. Hibbert. I rest my case.
You rest your case?
What? Oh, no, I thought that was just a figure of speech. Case closed.
Because being wrong seems like much less of a big deal when you directly contrast it with being completely incompetent.
The foreman will pass the verdict to the bailiff. This verdict is written on a cocktail napkin, and it still says guilty. And guilty is spelled wrong.
And this is because, as I've already mentioned earlier, when it comes to a takings clause remedy in particular, an injunctive remedy is impossible, and any such argument should be clearly identified as a non-starter, since the remedy of compensation is actually directly written into the Constitution. So while in some other cases, you can absolutely argue courts have a choice of what kind of remedy to order, and often more than one remedy will do. However, with the takings clause, there is no way to remedy the violation of his rights that he has suffered other than monetary compensation. And so ultimately, this is a very important case because despite the state of Texas's laughable opening remarks that claimed you will find no state more committed to the protection of property rights of its citizens than Texas.
Mr. Nielsen?
Mr. Chief Justice, and may it please the Court. The Court will be hard-pressed to find any government more committed to property than Texas. The Texas Constitution is more protective than the federal Constitution, and Texas courts under a Texas cause of action adjudicate takings claims under both constitutions. This appeal thus isn't about substantive rights. All petitioners had to do was use Texas's cause of action. Instead, petitioners insist they can bring a cause of action directly under the federal takings clause itself. This argument is wrong for many reasons. For one, it ignores what the Constitution says. Governments must provide just compensation, but the takings clause says nothing about how they must do it, whether through commissions, private bills, or litigation.
Now, Texas actually has a pretty equivocal history about actually protecting property rights in that, on the one hand, Texas does have a lot of very good rhetoric about protecting property rights, just as you would have expected from a largely conservative state. However, they also have a long history of undermining property rights for the benefits of various special interests, and in Texas, interests such as the oil and energy companies are especially powerful players. But another thing to consider here is that Texas, along with many state governments, have made no secret of the fact that they would like to at least have the option of seizing property without paying any compensation, at least in some instances, and that is a problem that cuts across the red-blue divide and should be of concern to every citizen in every state. Now, before I wrap this video up, I thought it would be interesting to cover an element of this case that seems to have gone largely ignored in coverage this case has gotten in corporate media, and even really among sort of the legal blogger content creator sphere that I guess I kind of fit into. Now, why they haven't covered it makes sense, insofar as understanding how Section 1441 functions as a means for Texas to remove this case, in particular, to federal court, really does actually make no difference in the outcome of the case. However, I think this is an immensely interesting discussion for people who are interested in developing a deeper and more comprehensive understanding of the workings of our Constitution, which, if you're watching one of my videos, I am going to assume is very likely you. So, how this worked was, they removed the case on the basis of Section 1441, which is a statute that essentially allows state governments to remove a claim to a case to federal court if it raises an issue that's within the original jurisdiction of the federal district courts. Now, the original jurisdiction clause in the Constitution, in Article 3, Section 2, Clause 2, states, in all cases affecting ambassadors and other public ministers and consuls, and those in which a state shall be party, the Supreme Court shall have original jurisdiction. And so in this case, the argument Texas made is that on the one hand, because this concerns the takings clause, a part of the federal Constitution, it is within the original jurisdiction of the federal courts. But on the other hand, Texas turns around and then says the federal courts don't have any jurisdiction to order a remedy.
Why don't you try speaking in words instead of your damn dirty lies?
And really, the most charitable way I could describe Texas's argument here is that their position is clearly a contradiction. However, the problem with this contradiction is that the federal courts bought it. The district court at least bought the jurisdictional part of the argument, but they didn't buy the part about how the court cannot order any remedy. However, in the Fifth Circuit on appeal, they accepted precisely that one possible resolution of this case could potentially be that there is no federal court remedy. But then they also say that Texas is not allowed to remove these cases to a federal court. However, if they did that, what we would be doing would be essentially creating a regime similar to the Williamson County regime, which the court said, as we've discussed in this video, was unacceptable in their 2019 Nick case for cases brought against local governments. And of course, the reason that these would apply as being unacceptable to local governments would also apply to why it would be unacceptable for a state government as well. So, in conclusion, if Texas were to prevail here, it would open up every single other state in the nation to using Texas's shockingly duplicitous opening argument that puts blame for this on the citizen, claiming they could bring this case in a Texas state court where they could find legal protections and a cause of action to sue for takings established under both the state and federal constitution. However, as we have already established, this is precisely how Mr. Devillier went about enforcing this right before Texas used 1441 to completely take that option off the table. And ultimately, this makes Texas's opening statement about the strong protection of property rights really one of the most shameless examples of victim blaming to ever come before the court. I mean, here, Texas is essentially demonstrating the same unwillingness to take responsibility for their own actions as a rapist insisting that he did nothing wrong because if his victim hadn't wanted to be assaulted, she could have dressed more modestly in a way that did not exacerbate his immoral and unlawful urges.
Hey.
Hey.
You walking home alone, huh?
Yeah.
You need a lift?
Oh, I'm okay. I mean, if I get raped, it'd be my fault for what I'm wearing.
And that is why, in this particular instance, the facts of this case are every bit as simple and straightforward and unequivocal as Mr. McNamara, who was Mr. Devillier's counsel in court on this case, presented in his own opening arguments.
We'll hear argument next in case 22-913, Devillier versus Texas. Mr. McNamara.
Mr. Chief Justice, and may it please the Court. The question presented in this case is resolved by the text of the Fifth Amendment, which, unlike any other provision of the Constitution, imposes on the government an explicit duty to pay money. It's also answered by this Court's decision in First English, which holds that the just compensation remedy is mandatory and that the Fifth Amendment itself furnishes a basis on which a court can award just compensation in an inverse condemnation case. And this right of property owners to sue in inverse condemnation to obtain just compensation for an alleged taking is at the heart of modern American takings law. It's at the heart of inverse condemnation claims filed against state and local governments nationwide, and it's also at the heart of every takings claim filed against the federal government under the Tucker Act. The Tucker Act provides no cause of action, no substantive entitlement to a remedy. The cause of action, the substantive entitlement to a remedy in every Tucker Act takings case, is the self-executing Fifth Amendment. The same cause of action recognized in First English, the same cause of action pled here. To reject that cause of action now is to upend the way lower courts, both state and federal, understand the Takings Clause to work, and also to abandon this Court's consistent explanations of that clause, not just in First English, but in more recent cases like Nick v. Township of Scott. And there's no reason to make that kind of drastic change. This Court has already recognized that money-mandating legal obligations logically come along with the right to file a lawsuit to enforce those obligations. That's true as to statutes, which is what this Court held in Maine Community Health Options. It should be at least as true as to the Constitution. And this Court's precedents consistently teach that it is. I welcome the Court's questions.
So in Takings Clause cases, including inverse condemnation cases, both the text of the Constitution and all relevant case precedent recognize the Takings Clause imposes a self-executing remedy that does not require a statutory cause of action. Period. Well, that's really all I have for you guys here today. So you're going to want to be sure to catch my next video that will be coming out very soon, because we are going to be covering the oral arguments from the 2 Chevron cases that were also recently heard before the court. Now, that episode will be a bombshell for anyone who has been following the progress of the Loper Bright case here on my channel for the last few years. Why do I say that? Well, that's what we're going to discuss in the next episode, so make sure that you stick around and subscribe to the channel, and please, if you would, do all those other things too that help to trigger Al Gore's rhythm. If you like this video, hit the thumbs up button. If you disliked it, hit the thumbs down button. Leave me a comment. Let me know what you thought about this case or its outcome, or just any thoughts you may have on this topic in general. I always like hearing what you guys think about the videos I make. So until next time, this has been Bob for Legalese, talking about Devillier v. Texas, and of course, as always, Cartago delenda est.